The
Honourable Nana Mahuta, tēnā koe.
Rangitāne o Manawatu, tēnā koutou. Nau mai, piki mai, kake mai, haere mai. Tēnei, te tehi mokopuna no te awa o Waikato e mihi ana ki a koutou ngā uri whakatupu o te awa o Manawatu. Kia taipai mai koutou I runga ki tēnei huarahi. Aha kua te aukaha o te awa. Aha kua ngā piko o te awa. Aha kua ngā auripo, ngā piki me ngā heke o a tāua nei awa. Ko tēnei huarahi te whae te tutuki o ngā take tiriti. He mea kia āta whakaarohia tātou ki ngā mokopuna, ngā uri whakatupu, a tātou mokopuna me a rātou nei whāinga. Nō reira, tēnei te mihi atu ki a koutou. Mr. Speaker, it is important to be able to spend some time at this first reading recognising the important juncture that we're at. And I would like to offer a few comments on the settlement, mainly drawing from the contribution of the Minister and some of the matters that he raised that would focus the efforts of the Select Committee. So I, in no particular order, have highlighted, Minister, both for your officials and for the technical team of the negotiators, some aspects that I intend to pursue as a means of seeking greater clarification around the intent of the deed of settlement and the way that it's reflected in legislation. And those issues go something like this. Firstly, the advisory board for the Manawatu catchment. In the way that the legislation is portrayed, it appears to me that the opportunity to disestablish the board might be preceded by the way in which the advisory board sees itself taking on greater functions in the freshwater management aspects of the Manawatu. If this is indeed the case, under the current RMA, the transfer of powers of Section 33 certainly allow iwi to be able to take on roles and functions for that purpose. And so I raise that as an issue because it might be something that the officials could offer us some advice on to what is the intent and purpose of the advisory board and what is the future opportunity space for the advisory board in freshwater management. The second issue I would like to ask some questions around will be the ongoing management of reserves and how your thinking is proceeding along the responsibility and the funding of that particular delegation of opportunity. You'll notice that these are quite technical questions to some extent, but they're important ones when we start to pursue the submissions that may come to us. Given some previous settlements and the challenges around access provisions to private land and public land, and I notice that there are some aspects of that within this bill, it's my view that it's worth the committee considering rights of access to protected sites, formal easements, whether or not that is the intention of what's required here in some instances, and we would have to understand the nature of the sites that we're talking about. And the last issue that has occupied the attention of the House for some time through various settlements is the way in which it's intended that the right of first refusal mechanism operates within the context of Rangitāne or Manawatu. This has been something that has popped its head up over all sorts of issues, but it will require the diligence of the Select Committee to make sure that what's reflected in the Act is what's intended in the deed of settlement. Minister, you have had a mammoth day today in bringing 3 settlement bills to the House. The efforts of your negotiating team and the negotiating team of Rangitāne or Manawatu is significant, and we recognise that. And while the first reading doesn't allow for all the acknowledgements that must be said to be said, be under no shadow of a doubt, once we go through the full process of the Select Committee and then back to the third reading, members will be heartened to bring the full extent of our recognition to the House for your satisfaction. Nō reira e te iwi o tāneki Manawatu. Tēnei te mihi atu ki a koutou ki a tātou katoa. Kia ora.